Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
Be ready. Start. Respondent number 1 issued a notification under Section 4 of the Land Acquisition Act wherein the entire land belonging to the petitioner, including the land which formed part of the sealing proceeding as aforesaid was a subject matter of that notification stop. On 8 1990 notification under Section 6 of the Land Acquisition Act was also issued stop. The declaration under Section 4 and 6 was challenged before the High Court in writ petition number 5462 of 1990, which writ petition was allowed on 28 1983, and the declaration under Section 6 was quashed stop. Under Section 6 of the Land Acquisition Act, the land of the petitioner was shown to be included in the said declaration stop. Consequently, award was made on 29 1982 and on 7 2001, which was challenged before Honorable High Court and was dismissed by a division bench wide order dated 5/1/2000 stop. The special leave petition was filed before the Honorable Supreme Court by the Agra Development Authority, and the award was amended as per order, and the amended award was published as per order of the Honorable Supreme Court stop. The petitioner's land, which was subject matter of the proceeding under the Sealing Act, was never transferred to the state government, nor any possession with regard to the same was taken by the state government stop. It is apparent from the possession certificate dated 33 1991 stop. This possession was acknowledged by respondent number 3, who directed the petitioner that since the compensation has been paid to the petitioner by mistake for the entire land, the same may be refunded by the petitioner along with interest for the land measuring 1 biga and 5 biswas, which does not form part of the acquisition proceedings stop. The petitioner approached respondent number 3 for depositing the said amount, but the said amount was not accepted, and therefore he approached respondent number 1 by means of representation and requested respondent number 1 to release the land in favor of the petitioner, and whatever compensation was received by the petitioner was directed to be refunded to the respondent number 4 through respondent number 3 stop. The said representation of the petitioner has been rejected by the respondent number 1 stop para. The state government filed its counter affidavit denying the averments as made, and filed affidavit of Shri Babu Ram, Under Secretary Awas Evam Shahri Niyojan Department, Government of UP, while denying the contentions raised in the writ petition stop. It is submitted that in notification under Section 4 of the Land Acquisition Act, the petitioner's plot number 460 was included, and subsequently notification under Section 6 was issued stop. The urgency clause was invoked stop. The contention that sealing proceedings were ex parte proceedings and notice under Section 10 within bracket 1 was not served is denied stop. It is contended that due procedure regarding sealing act was followed, and at this stage they need not reply stop. It is further contended that possession memo dated 33 1991 shows that possession of total area of plot number 460 have been handed over to the Agra Development Authority, who is at present in actual physical possession over the plot along with other plots stop.
The next dictation starts after 5 seconds.
Be ready. Start. Apart from this, it is also evident that there is no dispute with regard to the norms fixed under the government order dated 2011 1977 stop. The aforesaid government order is not under challenge stop. The government order categorically prescribes that no appointment should be made in excess of the norms as indicated therein stop. merely because the principal of the institution has initiated the proceeding and the DIOS erroneously granted the permission, the same would not crystallize any right conferred on the principal to make appointment to in excess of the norms. Stop. The government order therefore lays down a blanket ban on future appointments in excess of the norms prescribed. Stop. In my opinion, the principal committed a manifest error by seeking an approval of selections in respect of posts which were in excess of the norms of the government order dated 2011-1977 and to that extent the impugned order cannot be faulted with. Stop. The finding recorded by the Joint Director of Education, therefore fixing the number of posts available to the institution as 14 is absolutely correct and is a calculation made in accordance with the norms prescribed in the government order dated 2011-1977. Stop para. The selections which have proceeded indicate that the petitioners were part of a selection in which 16 appointments were allegedly proceeds. Stop. From a perusal of the impugned order, it appears that the candidates proposed in the selection proceedings submitted by the principal of the institution were in three categories. Stop. This is evident from the facts which have been recorded in the impugned order and is not disputed. Stop. The district inspector of schools was informed by the principal through the letter dated 15/9/2006 that 3 candidates have been selected in the scheduled caste category and 5 candidates in the OBC category. Stop. Similarly, 8 candidates were selected in the general category. Stop. The selections therefore proceeded category wise applying the reservation policy. Stop. The selections therefore were held under the impression that there were 16 posts available and accordingly the distribution was made category wise. Stop. It is thus evident that the selections which have been held are under an erroneous impression inasmuch as only 7 posts were available, whereas the selections have been held against 16 posts in different categories. Stop para. The question is whether the selection could have been held in the different categories provided the posts were available for each of the said categories. Stop. The impugned order records that there are 7 persons already working in the institution. Stop. Those who are admittedly working belong to the reserved category. Stop. The break-up which has been given in the impugned order is to the effect that out of 7 working employees, 5 are of the OBC category, 1 is a sweeper and 1 other employee is of the SC category. Stop. If the total number of posts is taken to be 14, then applying the provisions of reservation under the 1994 Act, the number of posts which are available to the OBC out of 14 comes to 3 and to the scheduled caste comes to 4. Stop.